So, picture this. A brand new law gets passed in Kenya that gives the government some serious power. We're talking about the power to sell off state-owned companies. Fast. As you can imagine, this sparked a huge legal fight that went all the way to the High Court. And the big question was, did the government basically cut Parliament out of the loop and grab too much control? All right, let's get into it.
And look, this isn't just some dry legal debate full of jargon. We're talking about the future of Kenya's most valuable public assets. The decision in this courtroom showdown, it was going to set a massive precedent for how power is balanced between the government and, well, the people's elected representatives.
So, here's our game plan. We're going to break down this landmark new law, dig into the constitutional challenge, look at what the High Court decided, touch on the role of public input, and then most importantly, figure out what this all means going forward.
All right, let's start at the beginning. What is this law that caused such an uproar? Okay, so the Privatization Act of 2025, really, it's all about one thing: speed. The whole point was to create a super streamlined process for selling off government-owned companies, making it way faster and more efficient than ever before.
Now, to really get how big of a deal this is, you got to look at the old way of doing things. Before this act, if the government wanted to sell a state asset, it had to get approval from Parliament for each individual sale. Yeah, every single one. It was slow, it was careful. This new law, it just rips up that whole rulebook. And no surprise, that's what triggered the immediate court battle.
Which brings us right to the heart of the fight, the constitutional challenge. So why did people take this law to court in the first place? What was the argument? Well, the main accusation was pretty straightforward. The folks who challenged the law said it basically sidelined Parliament, cutting it out of one of its most critical jobs, keeping an eye on the sale of the country's assets.
So it all boiled down to this. The challengers claimed the executive branch, the government, was basically handed a blank check. The court's job was to figure out if that was true and if it broke two fundamental constitutional rules, the separation of powers and what's called parliamentary oversight. So everyone was watching the High Court. How were the judges going to rule on this? I mean, this was a massive question about how Kenya's government is supposed to work.
And the verdict came in, and it was clear-cut. The High Court said the Privatization Act of 2025 was constitutional. It was legal. But the really interesting part isn't just what they decided, it's why.
To get the court's reasoning, we need a quick refresher on this idea of separation of powers. It's a core principle in many governments. The idea is simple. You split power between different branches. The legislative branch makes the laws, the executive branch carries them out, and the judicial branch interprets them. This way, no one part of the government gets too powerful.
And here's how the court saw it. They said the act didn't actually strip Parliament of its power. Instead, it just changed its job description. They argued the Treasury now proposes the sales, sure, but Parliament still has the final say because it holds the power to make the laws and oversee the whole system.
And that leads us right into the second big idea here: parliamentary oversight. This is just what it sounds like. It's Parliament's job to keep an eye on the executive branch and make sure it's playing by the rules that Parliament itself created. So this is the key takeaway from the court's decision. They basically said Parliament's job isn't to be a micromanager, stamping approved on every single deal. Its real constitutional duty is to build the framework, the system, the rules of the game. And by passing this act, the court decided that's exactly what Parliament had done. Okay, but that wasn't the only issue on the table. There was another piece to this legal puzzle. The challengers also said, hey, what about the public? We weren't properly consulted when this law was being created. So the court looked into that pretty carefully. They went back and reviewed the entire legislative process. They saw that, yep, public meetings were held, people had a chance to comment, and they concluded that the process did in fact meet the constitutional bar for public input. So that part of the challenge was dismissed. Okay, so the court case is over. The law is constitutional. So what happens now? What's the real-world impact of this decision?
Well, the biggest and most immediate consequence is that the government now has a clear green light. That legal roadblock is gone, and that means its big privatization program can finally kick into high gear, moving at that faster pace the law was designed for. And this isn't just theoretical stuff. We're talking about huge national assets. This ruling directly paves the way for the potential sale of major companies like the Kenya Pipeline Company, plus a whole list of other key state-owned businesses. They are now officially on the block. And this might be the single most important thing to understand about this whole situation. The court answered a very narrow question. Is the process in this new law legal? And the answer was yes. What the court did not answer is the much bigger, more complicated question. Is selling these specific assets actually a good idea for Kenya? That's a whole different debate, and it's one that now moves out of the courtroom and into the public square.
Yeah, this really hits the nail on the head. The court gave its stamp of approval on the how, the legal mechanics of selling these companies. But the why, the wisdom of the policy itself, that's still completely up for debate among the public, politicians, and experts.
So at the end of the day, the legal battle is over, but the public debate is really just getting started. The law is now settled. But the big question for Kenya remains, is this faster path to privatization the right one?